beyond that one, you have to go to, when you go to committee of the whole house, please, it is within your power, which cannot be taken away by anybody, to propose amendments. And you know, now it would have been very good that Honorable Ariko would be saying, I even proposed an amendment which was defeated, but I was proved right by the court. But if you just spoke about it in the committee and in second reading and never proposed an amendment, you know, once it is passed,
Attorney General, you are now acting as a speaker. You are coming back to yourself.
He was still very new. He did not know the procedure. Maybe next time he's going to propose it.
Thank you, but I think it's nevertheless still a valid point that indeed the state law office should at all times be involved in the drafting of any legislation that comes to Parliament. Even though Parliament has still the legal department, but the legal department can only do so much. And I think some of the staff who have introduced themselves here are in the legal department. And I think Honorable Ariko spoke with regard to the provisions of paragraph 8, isn't it? On the apparent overlap, which I had addressed. Sorry. Right. Paragraph 8. This bill takes the interest of each and every Kenyan. You know, it will be very difficult if we are not invested with the wherewithal to make that kind of economic determination, because again, you know, the State Department that originates the bill should be the one to say. And you know, it's not very easy to come up with something that incorporates the interests of each and every Kenyan. But I believe what they have done is to try, as much as possible, to try and capture the interests of as many Kenyans as possible. I do agree, however, that some of the observations made by the members, including the Honorable Njoki, that there are some of the people, because of how much they earn today, who may never be able to raise sufficient money to amount to a deposit as to qualify to get these houses. But I think again, that's a matter that since the bill is before the House, is a matter that the committee is at liberty to make proposals, amend as appropriate, because lawmaking, again, as I said, is within your powers. It's in your hands. Honorable Onyoro, again, whether we could take the parameters that that are used within the national government CDF, alongside alongside this, the proposals in this bill, again, it's a matter that would go to the State Department originating the bill. And I think I was assuming, Mr. Chairman, by now the very passionate principal secretary in that State Department has appeared before you and persuaded you in this. Because
he has appeared before this committee and he has done his part. Now, members, stop casting aspersions on anybody. Please proceed.
And I think, Mr. Chairman, the point you raised also as the model similar to the NSF, it's also a good proposal. I would just say, well, you know, this bill is actually, it's your report now, where it goes, or if it becomes law, it will become law on the basis of the recommendations that are going to come out of this committee. And I think, the Chairman, I see the committee very well represented, and I'm sure you will act in the best interest of the country, make propositions that reflect the best interests of the public, or at least the majority of the public of Kenya. there was an issue raised, is this by Honorable, who raised the issue of the possibility of one person, because of all the provisions of clause 33. Is this McLeod? Yes, Honorable McLeod. Actually, this is a real possibility. I've actually myself thought about it. But, well, listening to those that are dealing with operations, they seem to suggest that the system that is going to be put in place is one that will make it impossible for one person to acquire more than one of the houses. Although, again, that's a matter that if we are going that route, it's a matter that I think you need to tighten all the loose ends to avoid a situation whereby one person using several other people could purchase 10, 20 houses and maybe even allow those people to live there on some arrangement. This is possible. It is possible. I want to agree with you, Honorable McLeod. It is possible that can happen when we have this situation where we say they can surrender or can whatever transfer. It is possible, but again, because it has not become law, it is within the power of Honorable McLeod to make sure that certain eventuality does not see the light of day. This bill takes the interest of each and every Kenyan. It will be very difficult if we are not invested with the wherewithal to make that kind of economic determination. Because again, the State Department that originates the bill should be the one to say, and it's not very easy to come up with something that incorporates the interests of each and every Kenyan. But I believe what they have done is to try and, as much as possible, to try and capture the interests of as many Kenyans as possible. Parliament of course makes a lot of amendments. In fact, it is in Parliament where there are a lot of amendments, which is it's a very healthy democratic practice. Once it has been passed by Parliament, it is now left to the judiciary to interpret it. So if the judiciary finds something and to add in an act of Parliament, it is perfectly within their power to interpret and make the statement. But remember, whatever it is they do, they will not make the law.
Chairman, it is now apparently clear that this matter will have to proceed to Senate because of the functionality of the Constitution of the 4th schedule. So Chairman, we continue to require, because Chairman, we went through public participation and the public are saying, how do you keep a public land in Baringo, for example, to be constructed affordable housing, and in the long run, that land goes to a private person? So these are the issues that the AG, because of their clarity of thought and law, will continue to, help the state departments that you take to operationalize this process properly, so that we don't want a matter that when we pass in Parliament, it again brings litigation and we come back here, Mr. Chairman.
Thank you, Mr.
I feel that, there's a multi-sectorial way of approaching things. And I think when we leave here, right, things will happen in different places, from the AG's office, the State Department, the Finance, the Housing Committee. We've been to the public participation. I think the issues that really need to be addressed, and the Attorney General as an advisor of government, these issues came out very clearly from the public participation, the government-led, the devolved functions, the tax waivers that we're giving to the various companies that are going to be building the houses, and then the issue of levy tax fund. Right? People have this notion that if it's a levy and we're not getting houses, it should be a saving which we should get back. All right? If it's a tax, everybody knows when you pay a tax, it's gone to government to do what they have to do. If it's a fund like the fuel fund, nobody comes and asks you, the road levy fund, the road board fund, nobody comes and asks you, give us back that money. So I think as we continue calling it the housing levy, we've got to understand that those who contribute, who don't need houses, want that money back. And I feel that maybe we've stuck to this house levy, and we need to really think out of the box and ask ourselves, is this a tax that helps the government to provide the much needed houses, or is it a fund that is non-refundable and government provides houses and it's open to all? And the issue of deposit, I mean, people out there were saying, why are we even being asked for deposit when people are being taxed to provide these houses? So as the advisor of government, I feel that some of the things that we've picked on the public participation